Good morning. I hereby call to order this 14th meeting of the Pennsylvania Public Utility Commission for the year 2019 and ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much. Just want to also always, as normal, mention our safety information. Please note that it is in the inside of the cover of the agenda. Also note that the Commission will act on various matters at today's meeting, which is open to the public. However, since adequate forums have been made available for public participation in cases before this Commission, there is no opportunity for the public to address the Commission at this public meeting. The first matter on this morning's agenda is the approval of the minutes for August 8th, 2019, and I call on Commissioner Place, who is the editor.
Thank you very much. Firstly, I would like to note that Tom Bean's in the audience today, and it's great to see you back, Tom. To the business of the Commission, I've reviewed the minutes of the August 8, 2019 public meeting and move that they be approved as submitted.
You have heard the motion to approve the minutes. Is there a second?
Second.
Second by Commissioner Kennard. Any discussion or further edits? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Now we will call upon our Secretary, Rosemary Chiavetta, to lead us through this morning's agenda.
Good morning, Madam Chairman. Good morning, Commissioners.
Good morning.
Your various offices and bureaus present the following agenda items for your consideration. Therefore, let us begin on page 1 with the recommendation of Director Bechtel and the Bureau of Consumer Services that the Commission adopt the opinion and order regarding the Universal Service and Energy Conservation Plan proposed by Columbia Gas of Pennsylvania.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 2 and matters presented by Director Sophie and the Office of Special Assistants, it is recommended in an omnibus motion that the Commission adopt all of the items on page 2, beginning with the complaint of Nancy and James Colbert versus the Pico Energy Company, and continuing to include and end with the first item at the top of page 3, the complaint of Gwendolyn Mercer versus the Philadelphia Gas Works.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Sweet, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the proposed opinion and order in the complaint of Steve and Agnes Atu-Aheen versus the Philadelphia Gas Works.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Vice Chairman Sweet. Any discussion?
Chairman, I do have a motion on this matter.
Commissioner Coleman.
Thank you. I'd ask that my motion be entered in the record as though I read it in its entirety. Before the Commission for consideration are the exceptions filed by the complainant to the ALJ's initial decision, which dismissed with prejudice their formal complaint for their failure to appear at a hearing and prosecute their complaint. In their complaint against Philadelphia Gas Works, the complainants alleged that they were incorrectly charged on their bill. For relief, the complainants requested that the Commission facilitate an independent investigation into their meter and meter readings. The Commission scheduled this matter for a hearing on January 11, 2019 at 10 a.m. The complainants did not appear for the hearing. The hearing was concluded at 10:24 a.m. Mr. Atu-Aheen later appeared for the hearing around 12 p.m., although he asserts that he arrived at 10:25 a.m. In a conversation with the ALJ staff, he explained that his late arrival and requested another hearing be scheduled in the matter. On March 12, 2019, the Commission issued the ALJ's initial decision. Following the issuance of the initial decision, the complaint received an extension of time to file exceptions. In their exceptions, the complainant offered various reasons for the late arrival at the hearing. The complainants challenged the finding and they failed to appear. In their exceptions, the complainants also argued that no hearing should have been scheduled until the Commission ordered an independent investigation into their gas meter and the reading as requested by the complainant. Once a hearing is scheduled and duly notified by the Commission, it is the responsibility of the parties to appear and participate in the hearing. A party to a proceeding may request a continuance of a hearing. A continuance request should be submitted in writing at least 5 days prior to the hearing date, except for oral requests which may be made in a hearing before the presiding officer. If a party fails to appear at a scheduled or duly notified hearing and that failure was not unavoidable, the party will be deemed to have waived the opportunity to participate in the hearing in the matter. Here, the complainants waived the opportunity to participate in the hearing on their complaint. The complainants failed to appear at the scheduled and duly notified hearing, and a failure was not shown to be unavoidable. The complainants also failed to request a continuance. Following the hearing, the complainant made no attempt to contact the ALJ prior to the issuance of the initial decision, a time period for approximately 2 months. Mr. Atuhi, conversation with the ALJ staff the day of the hearing does not constitute a continuance request, and the explanation he offered that day is not properly before the Commission. The complainants had a responsibility to establish contact with the ALJ prior to the issuance of the initial decision, either by phone, written correspondence to explain the reason for failure to appear. The complainants did not do so. While the Commission has rescheduled a hearing when a pro se complainant has demonstrated good faith attempt to attend a hearing, such circumstances are not present in this case. First, the complainant's exceptions made clear that they were aware of the family emergency, which could prevent them from attending the hearing days before the hearing. In the conversation a day before the hearing, Mr. Atuhi asked PGW's counsel if the company would agree to a second continuance, but the complainants took no steps to notify the ALJ that there was a need for a continuance. Second, the complainants previously received a continuance in this matter and followed the proper procedure to do so, indicating that they were aware of the requirements of requesting a continuance. Third, the first continuance was granted so that the complainant could conduct discovery. However, the complainant made no attempt to conduct discovery of the formal or informal matter. Finally, the complainants have a history of similar behavior before the Commission. In 2013, formal complaint against PGW, Mr. Atuhi received 1 continuance to conduct discovery. After failing to conduct any discovery, he requested a second continuance the day before the hearing. The second continuance request was denied, and Mr. Atuhi failed to appear for the hearing. After providing Mr. Atuhi with the exception of time to file exceptions, the Commission adopted the ALJ's initial decision, which dismissed the complaint with prejudice and precluded Mr. Atuhi from filing any complaints regarding the same subject matter until he paid his balance with PGW due to the abuse of process. The ALJ's initial decision referenced several other complaint cases involving the complainants and noted that the complainants were also precluded from filing complaints against PECO Energy Company and their telephone utility for abuse of process. For these reasons, the complainant's exceptions related to the failure to appear and prosecute their complaint will be denied. Turning to the complaint's exceptions regarding the investigation into their gas meter and its readings, the Public Utility Code places the burden of proof upon the proponent of rule or order. As a proponent of rule or order, the complainants have the burden of proof in this matter. To establish a sufficient case and satisfy the burden of proof, the complainants must show that the utility is responsible or accountable for the problem described in the complaint. By not appearing for the scheduled hearing, the complainant failed to bear the burden of proof. Furthermore, PGW attempted to coordinate a meter test with the complainants through the proceeding, and the complainants failed to respond until such time as the hearing would have been delayed. The complaint's exceptions related to the testing of the meter will be denied as well. Therefore, I move that the complaint's exceptions are denied, the ALJ's initial decision be modified consistent with this motion, the formal complaint is dismissed with prejudice, and that the Office of Special Assistance prepare opinion and order consistent with this motion. Thank you.
You have heard the motion of Commissioner Coleman. Is there a second?
Second.
Second by Commissioner Kennard. Any discussion on the motion? Hearing none. All those in favor of the motion, say aye.
Aye.
Any opposed? The motion passes 5-0. On the matter as amended, if there's no objection, we'll take the previous roll call. Hearing none, the matter as amended passes 5-0.
It is recommended in an omnibus motion that the commission adopt the last item on page 3, the complaint of Eleni Di Sabatino versus the Pico Energy Company, and to include and end with the sole item on page 4, the complaint of William Lamack versus the Pike County Light and Power Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Sweet, second by Commissioner Place. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 5, in matters presented by Director Diskin and the Bureau of Technical Utility Services, it is recommended that in an omnibus motion, the commission adopt the first 2 items on page 5 regarding the cancellation of EGS licenses and the joint petition of Direct Energy.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second?
Motion by Commissioner Place, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the commission adopt the proposed tentative order regarding PPL's letter of notification.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman Sweet. Any discussion?
Yes, I have a statement on the matter.
Commissioner Place.
Thank you very much. Madam Secretary, I ask that my statement be placed in the record as I read it in its entirety. Before the Pennsylvania Public Utility Commission is the joint petition seeking a waiver in order to file a letter of notification together with the lawn. PPL Electric requests Commission approval to rebuild approximately 22.5 miles of existing 13869 kV transmission lines in Lehigh and Carbon counties. More specifically, PPL Electric seeks to reconstruct a section of the Hotto, Siegfried, and Siegfried East Palmerton transmission lines. Estimated cost of the lawn is $55.5 million. Siegfried East Palmerton was constructed in 1948, currently consisting of 21 newer steel monopoles, 25 steel lattice towers, and 187 wood pole structures. The average ages of these structures are 17, 68, and 51 years, respectively. And the expected service lives are 80 years for the lattice structures and 40 to 50 years for the wood structures. New monopoles are expected to have a service life of 70 years. PPL Electric further states that the wood structures are the greatest concern on this line. The Hotto Siegfried was constructed in 1914 and 1923, currently consisting of 23 newer steel monopoles, 260 steel lattice towers, and 5 wood pole structures. The average ages of these structures are 20, 98, and 43 years, respectively, and the expected service lives are 80 years for the lattice structures and 40 to 50 years for the wood structures. PPL Electric further states that the lattice towers and wood structures are the greatest concerns on the Hotto-Siegfried line. PPL Electric states that the 2018 assessment report identified 35% of the steel lattice tower structures and 78% of the wood structures inspected as reject structures requiring immediate restoration or replacement. Yet despite these reject assessments, PPL has adequately maintained the reliability of its transmission segment. Further data requests revealed that only 4 sustained outages occurred on the Hotto-Siegfried line over the last 13 years, and no sustained outages occurred on the Siegfried East Palmerton line. While the lines serve a total of 27,500 customers, the average number of affected customers per event was 6,244, with an average outage time of 7.6 hours for the 4 events. Given these parameters, the resulting per unit system average interruption duration index, SAIDI, cost is approximately $89 million per SAIDI improvement. This far exceeds the SAIDI improvement costs in PPL's long-term infrastructure investment plan of roughly $3 million per SAIDI improvement. As to the 4 sustained outage events, only 1 outage was related to a failing structure. One outage was caused by falling vegetation, while the causes of the 2 remaining outages were unknown. While this rebuild project may prevent structural outages, the vegetation outages may not be resolved, and there remains uncertainty as to the impacts on the other outages. However, the analysis herein assumes the most positive outcome for PPL's project, assuming the resolution of all 4 outages when calculating benefits to this total rebuild project. PPL has provided cost of service data for 3 different scenarios, which the company has marked as highly confidential. Upon my review, I believe that the data merits serious consideration of the maintenance scenario, rather than approval of the total rebuild scenario proposed in this joint petition. Consideration should include a discussion not only of the cost savings, but of the reliability benefits. While a total rebuild would likely eliminate most outage events, it does so at an inordinate cost. An examination of the nominal cost of service study results in a projected breakdown on a cost of service basis, enviably many years down the road. Only at that point is the cost of service of the new facility roughly equivalent to the cost of service of the maintenance scenario. As to consideration of reliability benefits, I would reiterate the significant challenges of this project to efficiently enhance reliability at a reasonable cost in terms of the SAIDI analysis. The history provided by PPL does not establish any trend of increased outages. In fact, PPL's latest outage in 2016 was only 12 minutes, the shortage of all reported outages. PPL was asked to provide evidence of future outage projections. Their response simply acknowledges that, quote, projected outages were not modeled for any of the alternative solutions described in the lawn, end of quote. Thus, a critical element of need was not provided to adequately and accurately evaluate this joint petition. In summary, PPL did not provide sufficient justification at this time to merit approval of this lawn project. I might be convinced otherwise with sound, well-documented evidence of impending and escalating outage projections, assuming that PPL continued its effective maintenance practices. However, PPL did not provide this information, and I am thus unable to vote in favor of this petition. I want to be clear that I am not proposing that this line should never be rebuilt. Rather, the cost of service and reliability data on the record indicates that it may be more efficient and cost-effective to do so at a later date. Thank you.
Thank you, Commissioner Place. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed?
Opposed?
The motion passes 4-1, noting the dissent of Commissioner Place.
Continuing on page 5, it is recommended that the commission adopt in an omnibus motion the application of RKB Energy Solutions and continue to include all of the items on page 6 in that motion, ending with the application of Columbia Gas of Pennsylvania.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by, excuse me, Vice Chairman Sweet, second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 7, in matters presented by Chief Counsel Hicks and the Law Bureau, it is recommended that the Commission adopt the proposed opinion and order in the petition for reconsideration and rescission filed by Green Crown Energy, LLC.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Sweet, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt the proposed order regarding the 2019 amendments to the Commission's CAP policy statement.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Vice Chairman Sweet. Any discussion?
I have a motion on the matter.
Vice Chairman Place, Commissioner Place.
Madam Secretary, I ask that my motion be placed into the record as if I had read it in its entirety. Before us today for consideration and disposition is the adoption of Customer Assistance Program, policy changes and amendments to the Commission's existing CAP policy statement. This undertaking began nearly 2 years ago, involved a holistic review of universal service and energy conservation programs, including an examination of the Commission's current energy burden thresholds, focusing on whether existing customer assistance programs are affordable for low-income customers. We want to extend our sincere gratitude, first and foremost, to the many stakeholders who participated in working meetings, stakeholder meetings, and those who submitted comments and information at this docket. You are engaged in these fundamental issues daily, and we appreciate the time and attention you gave to these dockets. It is a far richer product for your contributions. We would also like to specifically acknowledge the Commission's Bureau of Consumer Services and Law Bureau staff who worked tirelessly on this assignment, particularly Sarah Dewey, Joseph McGee, and Louise Fink-Smith. I would also like to acknowledge Angela Casahan and from David Sweet's office and Haley Book from my staff, who have shown exceptional aptitude, abilities, and effort throughout this effort. As a result of this docket, Pennsylvania is the first jurisdiction in the nation to complete a comprehensive energy burden and affordability study of households using customer income, billing, and payment information. With this accolade comes some lessons learned, data requests, and delays, but it ultimately delivered empirically derived results that have informed our decision-making and the policies we are considering here. Our final policy statement is comprehensive and reflective of not just the set facts presented by stakeholders, but the years of experience and expertise developed within this Commission in evaluating the successes and opportunities for improvement within universal service programs. This is not the Commission's first examination of topics such as energy affordability and whether the energy burden ranges first established in the 1992 CAP policy statement are adequate to address the energy assistance needs of low-income customers. The record on these issues is expansive and covers all aspects of the program. It is these years of deliberation on this subject matter that have culminated in what we are now considering, which are final amendments to the existing CAP policy statement. As such, we adopt the following amendments. Utilities should establish a new maximum tiered CAP energy burden of 6% for natural gas heating, 4% for electric non-heating, and 10% for electric heating for the federal poverty income guideline tiers of 51 to 100% and 101 to 150%. For the FPIG tier of 0 to 50%, a maximum energy burden of 4% for natural gas heating, 2% for electric non-heating, and 6% for electric heating. Utilities should implement minimum CAP payment requirements in universal service and energy conservation plan proceedings rather than in a CAP policy statement. Utilities may propose alternatives to a flat minimum payment for each account type, such as basing them on a household's FPIG level. Utilities should allow CAP households to retain CAP enrollment when a transfer of service occurs within the utilities or an affiliate utility's service territory. Utilities should accept income documentation of at least the last 30 days or 12 months, whichever is more beneficial to the household, when determining CAP eligibility at application or recertification. CAP applications and recertification letters should identify acceptable income timeframes and explain how each may benefit the customer. Utilities should not require that low-income customers be payment troubled to qualify for CAP. Utilities may, however, impose such a requirement to prioritize CAP enrollments and control CAP costs if determined appropriate by the Commission. Utilities should not require that a customer designate a low-income heating and home energy assistance program or grant to the utility sponsoring the CAP or be penalized for not applying for LIHEAP. However, all CAP customers should participate in LIHEAP if eligible. Utilities should also not use a LIHEAP grant to reduce the amount of CAP credits. Utilities should exempt CAP customers from late payment charges. Utilities should provide CAP customers with pre-program arrearage forgiveness for each on-time and in-full monthly CAP payment regardless of in-CAP arrears and retroactive PPA forgiveness for any months missed once the household pays its in-program balance in full. Utilities may request Social Security numbers, but not require them for household members when verifying identity for CAP enrollment. Utilities and entities acting on their behalf should offer and explain the options for providing other forms of appropriate identification on CAP applications at the time of CAP enrollment. Utilities should set maximum CAP credit limits in USCCP review proceedings rather than in the CAP policy statement, and they should consist of a tiered structure based on the household's FPIG level, which should provide lower-income households with higher CAP credit limits. Utilities should notify CAP customers when they approach their CAP credit limits, instruct them to contact the utility if they meet any exceptions, and if eligible, refer them to LIERP. Utilities should establish online CAP applications and allow customers to submit documentation electronically. Utilities should use a standardized zero-income form and develop other industry-wide standardized forms. Utilities should establish new maximum recertification timeframes for CAPs, requiring all households reporting no income to recertify at least every 6 months. Households that participate in LIHEAP annually should recertify at least once every 3 years. Households whose primary source of income is Social Security, supplemental security income, or a pension should recertify at least once every 3 years. And all other CAP households should recertify at least once every 2 years. Utilities should initiate collection activities for CAP accounts when a customer is no more than 2 in-program payments in arrears. Customers should not be removed or defaulted from CAP as a precursor to termination for non-payment. Utilities should evaluate household CAP bills at least quarterly to determine whether the company's CAP. I'll start that again. Utilities should evaluate household CAP bills at least quarterly to determine whether the customer's CAP credit amount or billing method is appropriate. Utilities may address recovery of CAP and other universal service costs from any ratepayer classes in their individual rate case filings. Utilities should work with stakeholders to develop customer education and outreach plans. Utilities should use the definition of household income as outlined in Chapter 14 of the Public Utility Code. These changes are consistent with the Public Utility Code and are reflective of numerous comments submitted by the stakeholders in this proceeding. A few of these decisions bear further discussion. Regarding energy burden thresholds, the Public Utility Code requires that utility service be universally affordable and that universal service and energy conservation programs be developed, maintained, and appropriately funded to ensure such affordability. In furtherance of this requirement, in 1992, the Commission published a CAP policy statement which established maximum energy burden ranges for low-income customers by heating source and income level. If a consumer's energy burden fell within these ranges, it was assumed to be affordable for a low-income household. However, the Commission noted in 2006 that these energy burden levels may be too high. In the Commission's final investigatory order on CAP funding levels and cost recovery mechanisms, the Commission stated that, and I quote, "Our policy requiring a low-income household to pay 17% of their household income for home energy services compared with an average household who pays 5% of their income may need to be revised," end of quote. In that order, the Commission expressed support for limiting customer payments to 10% of household income. In March 2017, the Commission directed BCS to initiate a study to determine what constitutes an affordable energy burden for Pennsylvania's low-income households and identify what policy changes are needed to bring universal service programs into alignment with any affordability recommendations. In January 2019, the Commission released a staff report entitled Home Energy Affordability for Low-Income Customers in Pennsylvania. The Energy Affordability Report noted that CAP customers, despite receiving discounted payments and/or debt forgiveness, had significantly higher energy burdens on average in comparison to non-CAP customers. While non-CAP customers had an average combined energy burden of 4%, the average combined energy burden for CAP customers 12 to 14%. The study also illuminated that CAP households with an income at or below 50% of the FPIG, regardless of heating or non-heating status and energy type, often had energy burdens well above the limits established in the CAP policy statement, for some utilities as high as 20%. To put this into perspective, under existing policies, a customer with an annual household income of $10,000 can spend an average anywhere from $1,200 to $2,000 a year or more on electric gas service combined. This vulnerable subset of customers is at greater risk of defaulting from utility customer assistance programs and faces higher rates of service termination due to late or missed payments, particularly for electric utility service. In recent years, the Commission has noted this trend in various USECP proceedings and subsequently directed utilities to work with interested parties to restructure caps in order to provide more affordable energy bills, particularly targeting customers in the greatest need of assistance. For the aforementioned reasons, we firmly believe that a maximum energy burden threshold of 6% for customers at or below 50% of the FPIG is warranted and agree with the joint comments filed by TURN, Cause PA, and Action Alliance, and senior citizens of Greater Philadelphia that, quote, customers at the lowest tiers of the federal poverty level cannot afford to pay 10% of monthly income for their energy bills. Such a high energy burden for the lowest income customers will fail to satisfy the statutory obligations of universal service and continue to lead to disproportionate termination numbers, end quote. Under this amendment, with a 6% maximum energy burden for the most vulnerable customers, a household with an annual income of $10,000 could potentially save an average of $1,000 or more annually on electric and gas service. This action will have a meaningful impact for the approximately 95,000 households with income from 0 to 50% of poverty enrolled in Pennsylvania's utilities caps, and all future households that would be income eligible and in need of energy assistance. Regarding recertification timeframes, the current CAP policy statement instructs electric distribution companies and natural gas distribution companies to establish a participant's eligibility for CAP benefits annually. However, in recent USECP proceedings, the Commission has approved some CAP recertification timeframes exceeding 1 year. The most common reason customers are removed from CAPs is due to failure to recertify. In situations where the household receives LIHEAP annually or has a fixed income, for example, Social Security, supplemental security income, or a pension, the Commission has allowed utilities to use alternative recertification requirements. In this proceeding, stakeholders offered various proposals for amending the recertification timeline for CAP customers who report zero income or receive LIHEAP grants. We respect the CAP customers who report zero. I'll start again. With respect to CAP customers who report zero income at the time of enrollment, we agree with the Energy Association of Pennsylvania, PPL, and PGW that these CAP customers should recertify more frequently, as it does not seem reasonable that a household can maintain living expenses for an extended period of time with no source of income. Therefore, we expect that households reporting zero income should be required to certify no less than once every 6 months. Furthermore, regarding LIHEAP, while we recognize the benefits of allowing LIHEAP recipients to remain in CAPs without frequent certification of income, we find that receipt of the grant itself is insufficient income documentation for the purposes of CAP. A LIHEAP grant only establishes that the household has income at or below 150% of the FPIG and therefore qualifies for CAP. However, it does not provide the utility with a household specific information necessary for the proper determination of CAP benefits. This is especially important as CAP benefits are tied to annual income. So by overextending the recertification period of LIHEAP recipients, we inadvertently run the risk of preventing otherwise eligible households from receiving greater payment assistance for the utility if, for example, their income was to decline in the interim. We therefore established a new maximum recertification timeframes for CAP customers, requiring all households reporting no income to recertify, as I note, at least every 6 months. Household participants who in LIHEAP annually to recertify at least once every 3 years. Households with primary source of income is SSI, Social Security, et cetera, pension, every 3 years, and all CAP customers recertified at least every 2 years. While the most common reason as noted, customers are removed from CAP due to failure to recertify. We acknowledge that frequency of recertification is a significant but not sole determinant of the suboptimal outcome. Another barrier is the process itself. Utilities should endeavor to find more effective ways of communicating this recertification policies and procedures and develop more efficient ways of collecting appropriate income information from customers in order to minimize disruption in CAP participation. Regarding definition of household income, participants in a utilities CAP is dependent on a customer's income. However, the definition of income is absent from the current CAP policy statement, and as a result, needlessly disparate policies exist in defining the parameters of qualification, creating a lack of uniformity in program implementation. To standardize this practice, we adopt the definition of income as described in Chapter 14 of the Public Utility Code. Chapter 14 defines household income as, I quote, the combined gross income of all adults in a residential household who benefit from the public utility service, end quote. This is the definition that guides the Commission on how household income is calculated for the purposes of payment arrangement requests, and arguably this should inform the utility calculation of household income as well. Adopting the Chapter 14 definition will ensure consistency among utilities and provide a singular definition to be used by both the Commission and regulated utilities. Regulated entities should update their USCCPs to reflect the Chapter 14 definition of household income, which excludes earned and unearned income of minors. Regarding customer education and outreach plans, while through these CAP policy statement amendments we are eliminating some barriers to universal service participation, we believe that education and outreach are paramount to awareness of and enrollment in these programs. While the current policy statement provides some guidance on consumer education and outreach, we are expanding the current text in order to provide more guidance on this central matter. As part of USCCP filing requirements, electric and gas utility companies submit a needs assessment, which uses census information and other available sources to identify the number of estimated low-income households in each service territory. These data are then overlaid with the number of customers enrolled in utilities CAP to identify the gap or the potential need in the service territory for low-income programming. While there is not a specific regulatory mandate that each utility must reach expressed as the percentage of low-income households enrolled in CAP, the near uniform disparity between the total number of potential income qualifying households and those actually receiving assistance calls into question the overall adequacy of consumer outreach and education. Historically, within Pennsylvania, only 30% of eligible households have been enrolled in utilities CAP, regardless of likely correlates such as economic performance, unseasonably hot summers, or unemployment rates. We are not convinced that this fact pattern is indicative of a need being met, but rather that it illuminates the need for increased awareness. We have noted in various USCCP proceedings the necessity for utilities to develop a more robust effort to reach customers, particularly the very marginal, for enrollment in universal service programs. This determination is further bolstered by the Commission's Emerging Leaders 2016 final recommendations to the Commission, which align with our action today. As such, utilities should develop a consumer outreach and education plan to be included in each part of USCCP filings. In reviewing ECP filings, we expect BCS to collaborate with the Commission's Office of Communications. While utilities have flexibility as to the contents of these plans, they should reflect a focused education and outreach effort specific to the demographics of their individual service territory, spanning the duration of the universal service plan period. Specifically, these plans should identify efforts to educate and enroll eligible and interested customers at or below 50% of FPIG. Additionally, consumer education outreach programs should identify resources and make available translation services and translated materials for those customers who are of limited English proficiency, which also applies to the services, materials, and technical assistance provided by partners or community-based organizations involved in the enrollments of service delivery associated with universal service programs. We believe these amendments to the current CAP policy statement will improve the delivery of assistance to low-income residents throughout this Commonwealth. Therefore, we move that, 1, The policy statement on customer assistance programs at 52 PA Code 69.261 through 69.267 is amended consistent with this motion. 2, the Law Bureau shall prepare a final policy statement order consistent with this motion. 3, following the entry of the final policy statement order, the Law Bureau shall deposit the final policy statement order and Annex A of the with the Legislative Reference Bureau for the publication in the Pennsylvania Bulletin. 4, the final policy statement will become effective upon publication in the Pennsylvania Bulletin. 5, a copy of this order, together with Annex A, be served on parties to energy affordability for low-income customers, docket number M 2017-258-7711, and review of energy service and energy conservation programs, docket number M 2017-259-6907. 6, the electric distribution companies and natural gas distribution companies at this docket shall file and serve addendums to their existing and proposed, if applicable, universal service and energy conservation plans at their respective dockets in response to this order within 60 days of entry date of this order. The addendums are to indicate how the electric distribution companies and natural gas distribution companies intend to implement the policy changes specific to the amended CAP policy statement, numbered as in the discussion herein by or after January 1st, 2021. The electric distribution companies and natural gas distribution companies should indicate in the cover letter to their addendums any provisions with which they are already compliant. 7, addendums to the Universal Service and Energy Conservation Plans shall be filed in both clean and red line copies and served on the parties of the utilities' respective existing and pending, if applicable, USCCP dockets. 8, the amendments to the Universal Service and Energy Conservation Plans shall be provided electronically in Word-compatible format to Joseph McGee, Bureau of Consumer Services, Jennifer Johnson, Bureau of Consumer Services, and Louise Fink-Smith, Law Bureau. 9, the electric distribution companies and natural gas distribution companies referenced in Energy Affordability for Low-Income Customers, docket number M's 2017-258-7711, and review of universal service and energy conservation programs, docket number M 2017-259-6907, be prepared to address recovery of customer assistance programs and other universal service costs in their next individual rate case proceedings, recognizing that non-residential classes need not be routinely considered exempt from universal service obligations. And 10, docket numbers M 2017-258-7711 and M 2017-259-6907 be marked closed. Thank you.
You have heard the joint motion of Vice Chairman Sweet and Commissioner Place. Is there a second to the motion? I will second the motion. Is there any discussion on the joint motion? Any?
I will step forward, although I was going to let the naysayers have the first crack at it, but let me just say a couple of things and then yield. Obviously, this is a big deal. It represents, at least for me, probably the single highest personal priority that I identified when I came to the commission. Want to reiterate the thanks that Commissioner Place has proffered to the Law Bureau and Louise particularly, and also BCS and Joe particularly. I flogged them a number of times to try to move this forward and apologize for my occasional impatience. I would also mention that there was one other commission staffer who really rode a laboring oar in this, and that was Kim Barrow of the chair's staff, and she too should be recognized along with Angela and Haley. Since joining the commission in 2016, my analysis of the uniform service programs was, first, that the very poorest among us, those that Commissioner Place described as living below 50% of the federal poverty guidelines, consistently pay an extremely high percentage of their income on electric and gas service. Secondly, that overall participation in the CAP programs was considerably low, stagnant at around 30% of those citizens and ratepayers who are eligible for those programs. Thirdly, that the Commission was not adequately monitoring utility compliance with the 1992 policy statement. And finally, that CAP costs were disproportionately varied across utility service territories, which unfortunately meant that residential ratepayers in certain parts of the state paid much more for energy assistance than others. My fundamental goal through both the energy affordability and the comprehensive review proceedings was to confront these matters directly and to find policy and regulatory solutions that would correct what I saw as major deficiencies in what is an important beneficial service available to nearly 2 million low-income customers living in Pennsylvania. I believe the revised policy statement will significantly address the majority of my concerns, given the reduction in the maximum combined cap energy burden from 17 to 6% for the absolute lowest income households, as well as the establishment of sophisticated consumer education and outreach plans and criteria as a way to improve upon the stagnant participation levels in CAP. Given the renewed attention to these important matters, I have no doubt that the Commission will be committed to assuring compliance with these goals. Regarding costs, the Energy Affordability Study published by Commission staff and released in January of this year provided a rough estimate of what these policy changes would cost non-CAP residential ratepayers. Staff estimated that on average CAP costs would increase annually by $15 or $1.25 per month, a perceivably nominal difference to what is a tremendous savings for customers who otherwise struggle to pay for a basic household necessity. However, admittedly, several important variables were not included in this estimate, and so the cost of our final proposed policy changes cannot yet be precisely identified. The onus will be on each electric distribution company and natural gas distribution company to either adopt these policies in Universal Service and Energy Conservation Plan proceedings or fully demonstrate why adoption cannot be met, especially considering the policy amendment that CAP costs can be recovered from all rate classes, not just residential customers. Yet none of this solves the unequal nature of how customers in different utility service territories are charged varying universal service costs. This becomes particularly apparent for the roughly 500,000 customers receiving natural gas distribution service from Philadelphia Gas Works, PGW. The average non-CAP PGW ratepayer pays $81.26 annually to support these programs in Philadelphia, nearly 7 times the amount of a national fuel gas customer in another part of the state. This anomaly occurs because CAP and other universal service programs, unlike most other states, are not funded through a statewide pool, but rather utility by utility based on service area. Philadelphia is home to a much larger number of citizens in poverty, nearly 250,000, than any other jurisdiction. And these residents would benefit the most from the proposed reductions to the energy burden thresholds. However, understanding that our action today will likely increase costs to PGW's non-CAP ratepayers, I encourage the utility to speak to this dilemma in its next USEP filing, noting that any attempts to forego inclusion of the proposed CAP policies for rate impact results, which I just described, while it might be a reasonable course of action, it also denies Philadelphia's poor from fully benefiting from greater CAP benefits. It will be a tough balancing act for PGW. PGW's unique situation goes beyond matters of universal service. The company annually pays $18 million to the city of Philadelphia and nearly $1 million to support the operations of the Philadelphia Gas Commission. Ironically, this is roughly the same estimated value that meeting the 6% energy burden identified today would cost PGW. I urge the city and its government to forego these payments from PGW and devote the money instead to a full-scale effort by PGW to significantly reduce the heating bills of its low-income residents. I personally can think of no better anti-poverty program. Moreover, the General Assembly should consider developing a statewide pool to support energy assistance in areas of high poverty, both urban and rural. Today, the Commission took the necessary steps to improve upon utility-sponsored energy assistance programs. And it is my expectation that as a result, utilities will heed Commission guidance on these issues. For the remainder of my term, I will be paying close attention to utility adherence to these policies, both in USEP proceedings and rate case filings, and encourage my colleagues to do so as well. I thank you.
Thank you, Vice Chairman Sweet. Any further discussion on the joint motion?
I have a statement, Madam Chairman.
Commissioner Kennard.
Thank you. And I ask that my written statement be read into the record as if I read it in its entirety, which I will not do. Under the Commission's existing policy, the combined electric and natural gas expenses of a customer are not to exceed 15 to 17% of household income, where that household is at or below 150% of the federal policy income guidelines. For customers outside of those parameters, the CAP program provides discounted bills to low-income customers. Currently, the program costs non-CAP residential customers $330 million per year. That is the contribution made by all ratepayers to support income-challenged citizens of the Commonwealth. The final policy statement presented today by the staff would reduce that energy burden down to 10%. The staff estimates that this will cost non-CAP residential ratepayers an additional $102 million per year, or approximately a 30% increase over existing spending. The joint motion then further proposes to go and drop the energy burden levels additionally downward by 6% for customers within the 0 to 50 federal guidelines and remain at 10% for 50 to 150%. The report does not analyze what the cost would be to customers of this additional consequence, but certainly we're now in greater than $102 million increase territory. I disagree with both the staff recommendation and the joint motion for several reasons. But first, let me say I've always supported our efforts to make energy affordable to those less fortunate. And I can certainly get behind the Vice Chairman's sentiments about we need to improve outreach if there's only a 30% participation, that we should more closely monitor. To me, these are the solutions to expand the program that we have, not to expand the program itself by further increasing the subsidy between paying customers and income challenged customers. We cannot simply open the ratepayer's checkbook to pay for others' bills. Of course, there's a particularly acute issue in Philadelphia, which has a 30% low-income population. The motions in the report do nothing to solve that problem. Our efforts should be supplemental to the social service programs devised by the General Assembly and the Governor's Office. There's nothing in the Public Utility Code that gives us a significant role in fighting poverty. Caps were not meant to solve poverty, but rather were established at a time when inflation in utility bills was growing faster than income, causing a disparity that was particularly acute for low-income customers. These conditions do not now exist. We already have one of the most generous programs in the nation. It's true that other states have maximum energy burden tests that are lower than those in Pennsylvania, but there are significant program differences that need to be recognized. For example, other states limit participation to LIEP recipients, we don't do that. We don't limit the participation. Much is made to the comparison of New York. In fact, I think what is happening here is we're adopting New York standards, but we're not adopting all of New York's program, because that program limits the total budget for each utility at 2% of their total revenues. As a point of reference, here in Pennsylvania in 2017, the EDCs, the electric companies, spent 2.5% of gross income, and the gas companies spent an average of 2.2%. So we're already spending more than New York, but by dropping the threshold down to the New York level without the cap, we're going to be far in excess of the spend in New York. Today's national economy is booming with unemployment levels at historic lows, and so too are energy prices extraordinarily low. Should the country go into recession and labor markets deteriorate, or should energy prices rise, cap spending will be larger than the estimated $430 million contained in the staff report, and it will be unconstrained because neither the staff report nor the joint motion agree to place a limit on overall spending. This exposure would result in pressuring all customers, including low-income non-cap customers, into being no longer able to afford their utility bills. Overall, I agree with the consumer advocates' comments that the caps as currently designed are working reasonably well. Rather than changing the maximum energy burdens, the OCA suggests making other modifications to the cap, including revising minimum payment requirements and pursuing budget billing. I think this is the right approach. As a last point, I believe that due process mandates that we must issue the revised policy statement as a proposal with a comment period, not as a final rulemaking. In all fairness, stakeholders should be provided with the opportunity to comment on the entire package of changes, many of which are so inextricably intertwined. And then finally, currently under our regulations, residential support programs are funded by residential ratepayers because the program benefits residential ratepayers. I strongly oppose the expansion of cap and universal service cost recovery to commercial and industrial rate classes. Large commercial and industrial entities neither benefit nor are they eligible for these programs. To restate a point made earlier, we are wandering into the arena of tax policy where general taxes like personal income or corporate and income taxes are used for the general public good. We are not the General Assembly and do not have the discretion to impose a tax for a public benefit. So in conclusion, I agree with many of the changes set forth in the policy statement and believe that cleaning up our cap process is a great idea and certainly timely. However, I do not see the need to decrease the maximum energy burden or to authorize drastic cost recovery mechanisms that significantly increase the cap spending that will result. For that reason, I will dissent, or I will vote no on the motion and no on the report. Thank you.
Thank you, Commissioner Kennard. Any further discussion on the joint motion? I would just like to place on the record my thanks to the staff, especially our Bureau of Consumer Services and our Law Bureau staff, and as well as the different commissioner assistants, including Kim Barrow in my office, for all the hard work. This is not an easy issue. But I do know that from the time I became a commissioner in 2013, I have constantly put comments on the record about I can't understand how we've let some people have gotten into the situation where they are coming before the commission with bills that are so high, or arrearages that are so high, and what could we do to address it? So I am thankful to my colleagues for bringing forward the C motions to try to address this issue. If there's no further comments on the joint motion.
Chairman, I do have a couple of comments I'd like to add to the record this morning.
Commissioner Coleman.
Thank you. I'd ask that my statement be entered in the record as though I read it in its entirety. I don't mean to prolong this conversation. I know you're probably all exhausted in hearing what we have to say this morning, but I would agree with Vice Chairman Sweet that this is a big deal. And we're talking about significant financial resources. And in my opinion, this is really about a balance to those that are paying and those that are in need of assistance. The piece that I think the overarching piece for me this morning that really troubles me, and Commissioner Kennard touched on this, and that is about the changes that we're making, and these are some very profound changes that have significant financial implication. And we have not accepted comments from stakeholders on this. And I find that particularly troubling in light of the fact that we are making significant changes. So for that reason, I have a couple of things, and I ask that you bear with me here for a few minutes, but I think they're worthy of putting onto the record this morning. You know, this process started 2 years ago, and I did vote for the joint motion to undertake a comprehensive review of Pennsylvania's universal service programs. And I did so because the Commission has an important obligation to look at these programs on a regular basis and monitor and evaluate, and when necessary, make the changes to the programs that we believe are necessary after receiving input from all stakeholders. I would say that in general, I'm pleased with the information that was collected and the conclusions that I was able to draw from it. To summarize, I think that the data shows that the Commission and the public utilities are meeting their respective obligations regarding universal service, and that the programs are adequately funded, and I'll talk about that in a minute. Well, there's no underlying crisis here, okay, and I'd emphasize that there's no underlying crisis that we're trying to address this morning, and I think that's important to understand with respect to the universal service programs. I do recognize that there is room for improvement. And our staff and stakeholders have provided many good suggestions for us to be considering, and I want to thank all of the stakeholders and our Law Bureau and our Bureau of Consumer Services for the hard work they've done. This is complicated. This is complex. And the geography of Pennsylvania is very, very diverse, and therefore we need to keep those things in mind as we're moving forward and making changes to universal service. I think it's important also to just reflect a minute on the current financial assistance that's being provided in Pennsylvania. I think this is a piece that generally gets overlooked. Commissioner Kennard touched on this, and I think it's important, again, to add this into the record just so we all understand and appreciate what is being done in Pennsylvania in financial assistance programs. Pennsylvania has a very robust universal service program, and according to the comments that we received, ranks second in the country of total assistance provided in just a few years ago. Unlike other states, Pennsylvania does not limit the amount of spend on energy assistance programs or the number of participants, nor do we require participants to enroll in other state or federal programs, such as the Low-Income Home Energy Assistance Program. In 2017, Pennsylvania's low-income payment trouble customers received $500 million in financial and other assistance to help with their energy bills. $500 million. So we're talking about significant amount of resources here. This amount included $94 million in LIHEAP grants and approximately $385 million in universal service program assistance. Of the $385 million spent on universal service programs, over $330 million was spent on caps. Pennsylvania's caps are currently designed and are working to help customers maintain their service. Cap customers pay most of their discounted energy utility bills. For many customers, caps have ended the cycle of non-payment and disconnection by moving these customers to more regular bill payment. It is also important to note that low-income customers do not necessarily need nor want to participate in cap. I think that's another important consideration here. There are other components of universal service which may meet their needs, and that the overwhelming majority, let me state this again, the overwhelming majority of low-income customers in Pennsylvania are not payment troubled. Again, it's important to understand the constituency that we're talking about here this morning. For these reasons, enrollment and budget levels cannot be the metric of success or failure for CAPS. CAPS enrollment and budgets will rise and fall in response to changes in utility rates and underlying economic conditions, which certainly makes sense. For example, over the last 10 years, CAP enrollments for natural gas distribution companies have declined significantly, most likely in response to persistently low natural gas prices, steady economic growth, and good employment opportunities. I think it's good news that more natural gas customers than 10 years ago are able to pay their utility bills without requiring other customers, many of them who are also low income, to subsidize their service. Is there opportunity for improvement? Absolutely there is. And I think, again, we've talked about some of those points here earlier today that I think are very good suggestions that will help improve the programs and the design and the operation of CAPS. I agree with many of the recommendations proposed by staff, which clarify and simplify CAPS. I also agree with the joint motions directive related to consumer education and outreach plans. Moving on to just a couple of the procedural and substantive concerns. As I stated 2 years ago, the design, budgeting, administration of universal service programs are complex and undertaking for our public utilities. By moving forward today with a final revised CAP policy statement and not accepting comments and pieces that we are talking about this morning that stakeholders have not had a chance to review and to contemplate and comment on, that the Commission disregards this complexity. The final revised CAP policy statement includes a combination of energy burdens and other changes which have not been put forth for comment. And again, I find that troubling. We have not fully assessed the financial impacts of what we're talking about here this morning and what we are going to be imposing upon ratepayers of Pennsylvania. I'm disappointed that we're skipping the important steps of providing all of the recommendations to the stakeholders for their review. We normally have a public comment period when we revise our regulations and policy statements. No pressing legal or practical reason has been identified for deviating from our standards. Without further information for stakeholders, I cannot conclude that the final revised CAP policy statement balances the interests of residential customers who benefit from CAP and the residential customers who are paying for CAP. I am particularly concerned with the cost impacts for customers between 151 and 250 of the federal poverty income guidelines. Those households with low to moderate incomes who are just beyond the eligibility requirement of CAP. I'm not concerned of the folks on the top that have the ability to pay additional costs for CAP programs or those that are benefiting. I'm concerned about the folks that are right at that line, that are just above it, that are managing as best they can. And again, what we're doing this morning is imposing an additional cost for that income class. And I think we need to fully understand what that is and what the implications may be for that class of customers. I highlight the comments of the Office of Consumer Advocate that, quote, the Commission must consider the impact of paying for the programs we have on non-participants. The impacts of the program costs disproportionately affect low-income customers who do not participate in the programs and are near poor whose incomes are too high to qualify for CAP, but who may also have trouble making their bill payments, end quote. The Commission must ensure that the universal service programs are operated in a cost-effective manner. The final revised CAP policy statement contains certain cost control measures, but also expands the benefits associated with CAP. The expansion will impact both the size and the cost of the program in ways that we have not sufficiently quantified. I would have preferred to receive feedback from the stakeholders on the combined effect of these program changes. CAP was designed as an alternative to traditional collection methods for low-income payment troubled customers. We must not lose sight of that objective. Additionally, I am troubled by the declaration in the joint motion that public utility service must be, quote, universally affordable. Well, that is an admirable sentiment. It is not an accurate statement of the law. CAP can assist, but cannot guarantee that every customer will be able to afford service at every location and in all circumstances. It is beyond the scope of this Commission's jurisdiction and authority to implement or otherwise convert public utility service into an entitlement program, and that's essentially what we're talking about doing today. For the reasons stated above, I cannot support the joint motion. While I agree with many of the recommendations that are put forth today, I'm troubled by the absence of public comment, which I think would be invaluable for us moving forward with these complex discussions. Without these comments, it is not clear that the final revised policy statement does enough to balance the interests of participating versus non-participating customers. Accordingly, I will be voting no on the joint motion this morning. Thank you, Chairman.
Thank you, Commissioner Coleman. Any further comments or discussion? Commissioner Place.
Yes, I have a statement on the matter. Thank you. Madam Secretary, I ask that my statement be placed in the record as if I had read it in its entirety. In addition to the joint motion on this matter, I would like to comment on two issues. Consideration of household incomes above 150% of the federal poverty income guideline and cost recovery. While the Commission's action today does not include households above 150% of FPIG, nor requires cost recovery for USECPs from all rate classes, I would encourage utilities to consider these options. In undertaking any review of the universal service programs in their entirety, the Commission must continue to balance the costs and benefits of these programs, as the changes just approved will inevitably impact program delivery and the costs of that delivery. In my review of the cost issue, I note that most restructured states provide for a competitively neutral funding mechanism for low-income programs, assessed on all energy customers. Currently in Pennsylvania, only residential ratepayers fund the universal service programs with the exception of customers of Philadelphia Gas Works. Pursuant to its Commission-approved tariff, PGW recovers all costs associated with its customer responsibility program, including general discounts and arrearage forgiveness, the senior citizen discount, and the costs of the home comfort program through universal service and energy conservation surcharge. All customers pay this volumetric universal service and energy conservation surcharge, currently 13 cents per 100 cubic feet. I would encourage utilities to propose a similarly structured volumetric charge assessed to all rate classes for funding universal service programs, as energy poverty is a societal issue, not solely weighted on a single rate class. This position is echoed by the Pennsylvania Departments of Aging, Community Development, Environmental Protection, Health and Human Services, in which they argue that expanding recovery of universal service costs to other rate classes would allow for increased efficacy, check my own reading, of programming. This position was further bolstered by the Office of Consumer Advocate and the low-income advocates in their comments to this docket. Of particular note, the low-income advocates highlighted that all ratepayers benefit whether directly or indirectly from these programs, and as such, it is proper to recover the costs from all ratepayers. I echo this reasoning and encourage utilities to broaden recovery of USECP costs beyond residential ratepayers. While the Commission was studying energy affordability, the United Way was also examining these topics from the broader vantage point of financial stability for Pennsylvania households. During 2018 and 19, the United Way of Pennsylvania conducted a financial hardship study for Pennsylvania to raise awareness of the challenges faced by what they refer to as ALICE households, asset-limited, income-constrained, employed, the working poor, and to mobilize support strategies and policies that move ALICE households towards financial stability. ALICE represents a growing number of households in Pennsylvania that are above the poverty line but do not earn enough to afford the basic necessities such as housing, childcare, food, transportation, health care, and technology. The United Way ALICE report argues that the absolute basic cost of living, a survival budget in Pennsylvania, is $59,340 for a family of four and $20,760 for a single adult. This family of four survival budget is more than double the federal poverty level of $24,600 per year for a family of that size, and yet still leaves families financially vulnerable and unable to cover basic costs. In 2017, of Pennsylvania's approximately 5 million households, 640,349 earned below the federal poverty level, that's 13%, and another 1.2 million, 24%, were ALICE households, a combined 37% of Pennsylvania's households struggling financially. Commission regulations at 52 PA Code 54.72 define a low-income customer as, quote, a residential utility customer whose household income is at or below 150% of the federal poverty guidelines, end quote. While I am not recommending a change to the definition of low-income customer, I'm encouraging utilities to increase their universal service offerings to those just above the low-income threshold to include ALICE households who may need assistance to maintain essential utility services. This suggestion is not novel, as other states of the and the Commission's own LIRP regulations allow for some households up to 200% of FPIG to qualify for these assistance programs. I would further encourage utilities to consider the inclusion of ALICE households in customer assistance programs as appropriate. At this juncture, select utilities have extended CAP or ECAP programs for which this group of customers qualifies. Some ECAPs offer extended but limited benefits, such as arrearage forgiveness. These customers may well pay full tariff rates, but receive the benefit of arrearage forgiveness with each in full and on-time payment. Although the survival budget in Pennsylvania is above the federal poverty line, assistance for these households would be significantly impactful. Thank you.
Thank you, Commissioner Place. Any further discussion? On the joint motion, all those in favor say aye.
Aye.
Any opposed?
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 The motion passes 3-0, noting the dissent of Commissioner Kennard and Commissioner Coleman. On the matter as amended, is there any objection to taking the previous roll call? 3-2. Or is there any further discussion on the matter as amended?
Chairman, just to be sure, it's a 3-2 vote on this
3-2.
matter? Thank you.
Said 3-0.
I'm sorry, 3-2.
That's okay.
But I did note the dissent of Commissioner Kennard. It's been a long day so far, so please forgive me. The joint motion passes 3-2, noting the dissent of Commissioner Kennard and Commissioner Coleman on the matter as amended. There's no objection to taking the previous roll call of 3-2. Hearing none, the matter as amended passes 3-2, once again noting the dissent of Commissioner Kennard and Commissioner Coleman.
Finally, on page 7, it is recommended that the Commission adopt the Notice of Proposed Rulemaking Order regarding universal service programs.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Vice Chairman Sweet. On the motion, is there any discussion on the motion? Excuse me. I do have a joint motion, so I'm going to turn it over to the Vice Chairman to preside. He likes getting this gavel. I just want to let everyone know that. So.
No, Madam Chair, I think you like to turn it over to me because I bumble around, and the glaring comparison is so obvious that you handle things so smoothly and so well, and I stammer and somehow get to the end. In any event, you are recognized.
Thank you very much, Vice Chairman. I do have a joint motion, that of myself and Commissioner Place, and I ask that our joint motion be spread upon the record in its entirety. I will not read it in its entirety. Today, the Commission took an important step by revising our Customer Assistance Program policy statement to update the energy burdens to more affordable levels for Pennsylvania's lowest income citizens, those at or below 150% of the federal poverty income guidelines. In doing so, the Commission carries out the mandate of Section 2802 of the Competition Act, which provides that the Commonwealth must, at a minimum, continue the protections, policies, and services that now assist customers who are low income to afford electric service. Regulations will provide the Commission with another tool to enforce any necessary changes to the utilities cap programs, energy burden levels, cap credit limits, and customer education requirements. Therefore, with this motion, we direct the commencement of a universal service rulemaking, which will include the amendments to the cap policy statement, which we just voted on. The new universal service rulemaking may also encompass the pending review of the Low-Income Usage Reduction Program, or LIRP, those rules, and any other changes to the Commission's universal service regulations necessary to ensure that the programs are reasonably structured to efficiently and effectively assist low-income ratepayers. As we task staff with this rulemaking, we are mindful of another mandate to Section 2203 of the Competition Act, that the Commission shall ensure that the universal service and energy conservation policies, activities, and services are appropriately funded and available in each natural gas distribution service territory. Programs under this paragraph shall be subject to the administrative oversight of the Commission, which shall ensure that the programs are operated in a cost-effective manner. Therefore, we move that 1, the Bureau of Consumer Services and the Law Bureau shall prepare an order consistent with this motion, and 2, the Bureau of Consumer Services and the Law Bureau shall prepare a comprehensive universal service rulemaking order no later than the first quarter of 2020.
Is there a second to the motion? I will second it. Any discussion?
Vice Chairman, I do have a statement on this matter.
You are recognized.
Thank you. I'd ask that my statement be entered in the record as I read it in its entirety. As you're hearing, we're moving from the action that we just took on policy and moving it to a proposed rulemaking. The existing regulations identify the filing schedule, the required elements of universal service plans, as well as the requirements for record maintenance, third-party verification, evaluation, and program reporting. The order would have proposed the following revisions to our regulations. The utilities provide a method for customers to donate to the Utilities Hardship Fund through e-billing by 2021. The utilities establish a Universal Service Advisory Committee to meet at least twice a year, and that the scope of the documents retained under the record maintenance provisions be expanded. These proposed modifications are within the authority and jurisdiction and may have improved the implementation and effectiveness of the universal service programs. Accordingly, I would have been inclined to issue the proposed rulemaking order for public comment. The proposed joint motion directs staff, among other things, to prepare the proposed rulemaking order, which codifies all of the provisions of the final CAP policy statement that we just discussed earlier in today's public meeting agenda. As I stated on this matter just a few minutes ago, that I believe that at a minimum that the Commission should have issued the revised policy statement for public comments before making final decision. And additionally, I'm not sure that it is wise or prudent to include all of the elements of the policy statement to be codified in the form of regulation. Therefore, I will be dissenting on this motion. Thank you.
Thank you. Is there any additional discussion? Seeing none, it has been moved and seconded on this matter. All those in favor will vote aye.
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 Aye. Those opposed?
Opposed?
The motion carries 3-2, noting the dissents of Commissioners Kennard and Coleman. If it is acceptable, we'll have the same roll call recorded for the motion as amended. Seeing no objection, that will be duly recorded. Madam Chair, I turn the gavel back over to you.
Thank you very much. Madam Secretary.
Turning to page 8, and matters presented by Chief ALJ Rainey and the Office of Administrative Law Judge. It is recommended that the Commission adopt ALJ Dunderdale's initial decision in the complaint of Doug Walls versus the West Penn Power Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second?
Motion by Commissioner Place, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the Commission adopt Deputy Chief ALJ Pell's recommended decision approving the settlement in the rate case of UGI Utilities.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion?
Madam Chair, I have a motion.
Vice Chairman Sweet.
Thank you. Madam Secretary, please enter my motion into the record as if I'd read it in its entirety. And I think I will not even read the short statement. Let me just summarize in a sentence or two. The matter before us is a full settlement. There is one sentence in the settlement, or several sentences, that create an ambiguity because at one point a matter is, well, let me not get into the ambiguity. The motion is to clarify this matter. I realize that this change is amending a full settlement. In adopting this settlement, we're adopting, among other things, another settlement provision which says that the parties have a 5-day period in which to withdraw from the settlement. Should any party disagree with the amendment directed herein, they may avail themselves of that 5-day withdrawal period. Therefore, I move that paragraph 38 of the recommended decision of Administrative Law Judge Pell be amended to omit the following sentence, quote, UGI Gas will be permitted to recover all information technology costs associated with formalizing this practice in its customer billing system through its rider USP, close quote. The recommended decision should be adopted as amended, and the Office of Special Assistance prepare an order consistent with this motion. Thank you.
You have heard the motion of Commissioner Vice Chairman Sweet. Is there a second to the motion?
Second.
Second by Commissioner Kennard. Any discussion on the motion?
Yes, I have a statement on the motion in its
Commissioner
entirety.
Place.
Madam Secretary, I ask that my statement be placed in the records if I'd read it in its entirety. For the Commission for consideration is the base rate proceeding for UGI Utilities Incorporated Gas Division, the joint petition for approval of settlement of all issues, and the recommended decision of Administrative Law Judge Christopher P. Pell, my mistake. Apologies. While I do support the RD to approve the settlement, I want to note my strong encouragement to the parties to resolve amicably in the near future natural gas supplier access to peaking and storage assets. As noted by the NGSs, UGI does not release to suppliers any physical storage that customers pay for in their demand charges, which results in a competitive disadvantage for suppliers versus default service providers. Most Mid-Atlantic natural gas utilities have some storage mechanism that suppliers utilize on behalf of customers. When NGSs have access to storage assets, the supplier has the flexibility to optimize and deliver the storage gas on days when gas supplies are low cost. In the winter, suppliers will typically extract this gas from storage on cold days, high price days, mitigating potential price impacts on customers. On August 31, 2017, the Commission adopted an advance notice of proposed rulemaking order to solicit comments about amending and adding to our regulations. These regulations address the release, assignment, and transfer of capacity among natural gas distribution companies and natural gas suppliers. In that ANOPR, the Commission proposed that an NGDC holding contracts for firm storage or transportation capacity, including gas supply contracts with Commonwealth producers or a city natural gas distribution operation, may release, assign, or transfer the capacity or Commonwealth supply in whole or in part associated with these contracts to licensed NGSs or large commercial or industrial customers on its system. The Commission further proposed that a release, assignment, or transfer of capacity or Pennsylvania supply shall be subject to applicable contractual arrangements and tariffs. Capacity or Pennsylvania supply costs shall be charged to all customers as a non-bypassable charge based on the average contract rates for those services. Lastly, that same order emphasized the need to release all capacity where feasible, including consideration of proxy or virtual access. As part of this settlement, UGI has committed to analyze by March 1st, 2020, the capability to provide a virtual storage proposal to NGSs who provide choice natural gas supply service on the UGI gas distribution system, which will allow suppliers to manage injections and withdrawals of supply through nominations made to the company. Thereafter, the company shall hold a collaborative meeting for stakeholder input, and pending the outcome of that collaborative, may make a VSP filing with the Commission by no later than October 1, 2020. I strongly support this settlement provision to provide more equitable access to system, transportation, storage, and peaking access assets, which would enable NGSs to offer competitive rates and services to retail customers. I encourage the company, which is currently lagging behind much of the rest of the industry on this matter, to move expeditiously to resolve this inequity. Thank you.
Thank you, Commissioner Place. Any further comments or discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Is there any objection to taking the previous roll call on the matter as amended? Seeing none, the matter as amended passes 5-0.
Madam Chairman, that concludes regular agenda. Turning to the carry-in, on page 1 of the carry-in, it is recommended by the Law Bureau that the commission adopt the proposed tentative order regarding the Act 129 TRC test for EE&C plans.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Kennard. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It should be noted that the second item regarding ARD Operating LLC has been postponed until the public meeting of October 3rd. And finally, at the bottom of page 1 of the carry-in, it is recommended by the Law Bureau that the Commission adopt the proposed ratification order regarding the James Black Water Service Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard and second by Commissioner Coleman. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, that concludes all agenda items for consideration today.
Thank you very much. And before we close out, we do want to take this opportunity to recognize next week, September 22nd through September 28th, as Rail Safety Week. This is an annual recognition of Operation Lifesaver, a national rail safety education nonprofit. The PUC, along with state leaders in the U.S. Department of Transportation and other partner organizations, support this nationally recognized effort to raise awareness and highlight the importance of rail safety education. The PUC is an Operation Lifesaver partner and is dedicated to the goal of raising awareness about the importance of rail safety and empowering the general public to keep themselves safe near railroad crossings and along railroad rights-of-ways. Our PUC rail safety engineers and inspectors are in the field daily, focusing on the safety of the public. Part of this week's mission is to reduce collision, fatalities, and injuries at the high rail crossings and prevent trespassing on or near railroad tracks. While the number of crossing collisions, deaths, and injuries has dropped over the past 5 decades, it's still a startling fact that about every 3 hours in the U.S., a person or vehicle is hit by a train. So together, we can increase awareness of rail safety year-round. And without further business coming before us, I will note that we do have a retirement recognition, so we would ask everyone to please stay. But is there a motion to adjourn?
So moved.
Is there a second?
Second.
Motion by Commissioner Kennard, second by Vice Chairman Sweet to adjourn. There's no discussion on adjournment, and I don't think anyone would have discussion. So all those in favor say aye.
Aye.
Any opposed? We are adjourned.